This is Barry Zalma on insurance, and today I'd like to speak about punitive damages for the tort of bad faith and insurance for punitive damages. Insurers generally argue that they cannot or should not indemnify or insure for punitive damages awards because to do so would defeat the punishment aspect of punitive damages. Insurance carriers typically rely, for example in California, on public policy and point to California Insurance Code Section 533, which states an insurer is not liable for a loss caused by the willful act of the insured, but he is not exonerated by the negligence of the insured or of the insured's agents or others. The purpose of punitive damages is to punish wrongdoers and thereby deter the commission of wrongful acts. In Neal v. Farmers, a 1978 decision of the California Supreme Court, it set forth three factors relevant to the assessment of punitive damages. 1. The degree of reprehensibility of the act. 2. The amount of compensatory damages awarded. And 3. The wealth of the particular defendant. The primary purpose of compensatory damages is fundamentally different from punitive damages. Compensatory damages are in existence to make plaintiffs whole, not to deter future harm. There is simply no reason why punitive damages should be limited by some fixed ratio to actual damages. In BMW of North America versus Gore, a 1996 decision of the U.S. Supreme Court, it first announced three guideposts for assessing the constitutionality of punitive damages awards, almost identical to those set forth in Neal. BMW was the first time the U.S. Supreme Court had ever struck down a punitive damages award as unconstitutionally excessive. The court reaffirmed BMW in questioning the size of a punitive damages award in Cooper Industries and in State Farm Mutual versus Campbell, a 2003 decision, where the Supreme Court limited the amount of punitive damages to a small multiplier of compensatory damages. Insurance carriers frequently cite Peterson versus Superior Court, a 1982 decision of the California Supreme Court, in their argument. The Peterson court addressed the question of whether imposition of punitive damages negates an insured's coverage for compensatory damages as well as punitive damages. It stated that indemnification of the punitive damages is disallowed for public policy reasons. Many courts have recognized that the California Insurance Code's Section 533's bar against coverage does not apply when an insured's liability is based on the acts of its agents, employees, or representatives, at least absent evidence that the insured, or in the case of a corporation, its board of directors, authorized or ratified the intentionally wrongful conduct. For example, in Aronson v. National Automobile and Casualty, a 1955 decision of the California Supreme Court, the insured's son, a minor, started a fire that damaged school property, and the school district obtained a judgment against the plaintiff for the amount of damage. The carrier refused to defend the suit or to pay the amount of the judgment, claiming that the injury was caused intentionally by an insured and therefore fell within an intentional acts exclusion or alternatively Section 533. The court held that Section 533 has no application to a situation where the insured is not personally at fault. It apparently ignored the fact that a minor child living with his parents is also an insured, and that minor child was personally at fault. Illinois state courts have held that public policy prohibits insurance against liability for punitive damages that arise out of the misconduct of the insured in a case called Fox versus American Alternative, a 2014 decision, and Ironshore Specialty, a 2021 decision. A claim for bad faith conduct that breaches the common law duty to deal fairly and in good faith with its insured can potentially result in three types of damages. 1. Benefit of the bargain damages for an accompanying breach of contract claims. 2. Compensatory damages for the tort of bad faith. And 3. Punitive damages for intentional, malicious, fraudulent, or grossly negligent conduct. Even in jurisdictions that allow insurance coverage for punitive damages, a court must properly consider what was necessary to determine the insurability of exemplary damages by weighing the interest in enforcing agreements versus the public policy interest against such enforcement. The court did so and decided that the application of Fairfield Insurance Company versus Stevens Martin Paving, a 2008 decision of the Texas Supreme Court, to the facts of the case, counsels against the insurability of punitive damages awarded against a drunk driver, where the underlying trial the jury found the driver engaged in certain specific conduct. Pennsylvania's long-standing rule that a claim for punitive damages against a tortfeasor who is personally guilty of outrageous and wanton misconduct is excluded from insurance coverage as a matter of law, and that the case of Esmond versus Licio, a 1966 decision of the Pennsylvania Superior Court appellate case, held that the public policy does not permit a tortfeasor to shift the burden of punitive damages to his insurer. This rule is based on the view that punitive damages are not intended as compensation, but are rather a penalty imposed to punish the defendant and to deter him and others from similar outrageous conduct. To permit insurance against the sanction of punitive damages would be to permit such offenders to purchase freedom from the offender's misconduct altogether, inconsistent with the theory of civil punishment which such damages represent. Furthermore, shifting punitive damages to insurers would result in insurers pricing up policies to factor in drivers who behave egregiously. Because Pennsylvania law prohibits insurers from providing coverage for punitive damages in order to ensure that tortfeasors are directly punished, the court held that Allstate could not be responsible for punitive damages incurred in an underlying lawsuit. To hold otherwise would shift the burden of the punitive damages to the insurer, in clear contradiction of Pennsylvania public policy. This was a case called Wolf versus Allstate, a 2015 decision of the Third Circuit Court of Appeal. In Dart Industries versus Liberty Mutual, a 1973 decision of the Ninth Circuit, the underlying complaint alleged that the insured corporation's president sent a defamatory letter to a customer on corporate letterhead. The jury found that the president intentionally spread the falsehoods contained in the letter. The carrier contended that Section 533 precluded coverage for the underlying lawsuit. The court disagreed. The court held that Section 533 does not bar coverage for a corporation where there remains a complete absence of proof that the policy-making management of the corporation approved, ratified, or had any knowledge of the letter or its liable. So in Dart Industries, the insurer failed to complete a thorough investigation to produce the evidence necessary to support its refusal. Although California Insurance Code Section 533 bars an indemnity of an insured who personally commits an act of malicious prosecution, the statute does not bar indemnity of an insured who does not personally commit the act but who is vicariously liable for another person's act of malicious prosecution. In Fireman's Fund versus the City of Turlock, a 1985 decision of the California Court of Appeal, the underlying lawsuit alleged breach of contract and fraud against the insured city and city attorney for acts and or events that transpired surrounding the firing, reinstatement, and termination of a police officer. A jury awarded the plaintiff damages against both the city and the city attorney on the fraud cause of action. The primary carrier filed suit against an umbrella carrier, claiming that the underlying action was covered under the umbrella policy. The court held that Section 533 did not bar coverage for the city absent a finding that the city ratified the city attorney's fraudulent promise, even though the city attorney was empowered in a managerial capacity and made the fraudulent promise while acting within the scope of her employment. In New Mexico, the purpose of punitive damages is twofold. Such additional damages are awarded for the limited purpose of punishment and to deter others from the commission of like offenses. The purpose of requiring an insurer to provide coverage is to be sure that an insured is compensated for injuries even when the tortfeasor is financially irresponsible. In the past, when holding that insurance policies may cover punitive damages, the New Mexico Supreme Court relied on the principle that the purpose of punitive damages, to punish the tortfeasor, is not diluted by requiring the insurance company to pay the damages, because the insurer can always sue the tortfeasor for recovery of the damages. When the tortfeasor cannot be punished for his culpable behavior, punitive damages no longer have the desired effect, and therefore the victim loses the legal entitlement to recover those damages. This was Dockery versus Allstate, a 2020 decision of the U.S. District Court for the District of New Mexico. On the other hand, Texas has, nonetheless, interpreted its law to permit such coverage. In Home Indemnity versus Tyler, a 1975 decision, and Home Insurance Company versus Safeway, a 1987 decision, where Texas courts have interpreted the all sums phrase that the term encompasses punitive damages. Both the Ohio legislature and the judiciary have articulated a clear policy against the insurability of punitive damages, and that a contract provision which contravenes that policy must be declared void. The public policy prohibiting the protection of insurance for punitive damages stems from the underlying assumption that an individual should not be able to escape punishment for his or her intentionally malicious acts, and that the deterrent effect of punitive damages would be diminished if tortfeasors can be indemnified against them. However, the Texas court, answering a certified question from the United States Court of Appeal for the Fifth Circuit, concluded that the Texas public policy does not prohibit coverage under the type of workers' compensation and employers' liability insurance policies at issue in the case called Fairfield versus Stevens Martin Paving. Even if there is a sufficient basis for an award of punitive damages against an insured, that does not mean that there is no insurance coverage available for that award. There are no hard and fast rules. Even when a public policy is clearly stated, there are always the opportunity for exceptions that cause insurers and their representatives to recognize. This video was adapted from my newest book, Zelma on Insurance Claims, Part 106, 3rd edition, adding to and correcting and updating this 2nd edition. It is available as both a paperback and a Kindle book, as well as a hardcover from Amazon.com. If you found this video to be interesting or useful, please pass it on to your colleagues. It's free. And please also subscribe to my YouTube channel and my Rumble channel, clicking on the like button and the Rumble buttons as you view. And please also subscribe to my blog and my Substack publications so that you can be advised of future blog postings and future videos. Thank you for your attention.